Yes, welcome back to the New State Project. Finally, after all these weeks, seems like years, but it's been a long time since we've been doing the show live from the fortified compound here in Mesa, Arizona. A lot of tech issues, but I think we got them all squared away, but I shouldn't talk too soon there. We never know. I mean, it was really odd as to what was going on, and it seemed like it was the mixer, because the caller line wasn't coming through either. So it seemed to kind of say that, it was, that it wasn't just a bad microphone, it was the mixer. But, while after the show yesterday, I tried a different microphone, and I don't know. It seemed to be working just fine. For some reason, hopefully there's people that are chatting here, but I'm not actually getting any of that. Oh, there we go. It has been a while, but we are live from 4 to 5 Mountain Standard Time today. Again, I would have done the show yesterday, but I'm glad to be back here. I tell you, I don't know how anybody can, especially self-proclaimed anarchists, support someone like Donald Trump. Oh, that's right, because leftist ideology is so unbelievably dangerous that a nut job like Trump is a better choice. Leftist ideology's only goal is the complete and utter destruction of Western society. Oh my gosh, yeah. I've heard it all before. But here, I'd like to see at least some of these journalists ask really good questions, because it's like first year journalism kind of stuff. Even if you're not a trained journalist, when you have something going on with these politicians and saying the things that they're saying, first he says for years that Mexico is going to pay for the concrete wall. Then he shuts down the government, saying that Congress, the Democrats, who have not controlled the House and Senate for 2 years, they could have gotten passed whatever they wanted. It's still the libtards' fault. So he shuts the government down, and he's doing it because the Democrats won't give him the money to pay for the wall, even though he said Mexico would pay for the wall, and he's come out and said that Mexico is paying for the wall because of the unbelievably good, probably the best ever, trade deal in world history, that the trade deal between the United States, Canada, and Mexico will go to pay for the wall. So why does he keep the government shut down? I honestly believe, especially what's come out this week, and again, I am not a fan of Robert Mueller. Okay? And so I mentioned this to someone the other day, that Mueller was the one in charge, I believe, of the FBI, knowing that almost half of the hijackers that they had listed were pictures from 9/11. That knowing that the passports were stolen, that those weren't actually the people who were involved with it, never changed it. Never updated it to say, we don't know what the hell they look like. We have no idea who they are, because it takes away from the narrative, which the official conspiracy theory is so full of holes. But I don't have time to get into that. When you pull something like that off, you get to shoot people in the face and get away with it. Because, well, then again, shooting somebody in the face is a hell of a lot less violent overall than what they were doing in the Middle East, for heaven's sakes. The millions of people, the thousands and thousands and thousands of innocent people that have died initially and continue to die. Right up at the present time, when we got school buses with children being bombed. Yeah. So so someone needs to just say, you just have been saying and tweeting, Mexico is indirectly paying for the wall. Why do you need Congress to pass a bill to pay for it? Because the shutdown I'm going to put my speculation hat on. It's not about that. It's about the information and the investigation of Robert Mueller and the other investigations, because maybe he figures he can stall the investigation. I'm just, I'm spitballing here. Why else? If Mexico is paying for the wall, why do you need a bill from the Democrats? And also what came out was that Manafort's lawyers didn't redact a filing, and so they've got actual evidence. They don't need Manafort's testimony. They got actual proof of collusion with Russian intelligence. Someone's saying, cool shirt, Mark. I had one I was like 14. Hey, I gotta address this because Iron Maiden never goes out of style, especially when you're talking about peace of mind. Yeah, I had a shirt like this when I was 14 too. But if you're seriously trying to say that you can outgrow Iron Maiden, then I'll put the good video and audio. I'll tweak the graphics, and so I'll show some of the documents that they would, and some of the more links and information about the Manafort thing. He was the campaign manager who was communicating, and now they got evidence communicating with foreign Russian intelligence. And wow, this is more than just paying off porn stars. This is some pretty serious stuff. Again, I am not a fan of Robert Mueller, but I'm not going to go out and say that all the facts and all the sources, that they're all lying as this grand conspiracy because they hate Donald Trump because he's trying to get rid of the deep state, or this QAnon crap that Donald Trump is actually working with Mueller. I guess that's what you need to do. Spout crap like that while playing a video game, and people will flock to your channel. It's like a phenomenon. The biggest channels and some of the biggest money makers are just people sitting in front of a microphone while they're playing video games. I had no idea that this was such. I'll take care of that. So let's get to the calls. We got area code 424. You're live on the No Stay Project. What's your name? Where are you calling from?
Hey, good afternoon, Mark. This is Ian.
Ian
Hello?
from California?
Yes, sir.
Okay. We're pretty informal here. Just Mark is good. Well, Ian, what can we do for you today?
I just wanted to thank you for what you're doing for the people, and you don't know how much you've helped me, and I just want to say thank you.
Oh, you're welcome. I do appreciate that. Do you have a pending issue now in court that you need help with?
Yeah. Yes, sir. Yes, sir. Yeah, I just need some prepping. I've already did the arraignment. The judge bullied me, he just ran over he said my motion was weak. I'd gotten a hand of a motion, and it was pretty brutal. I let the judge know that he was practicing law from the bench because I did not.
Yes.
Sorry about that.
That I did no problem. That I did not enter a plea, and he said he was protecting my rights by doing so. And
okay. Did you actually refuse to plea?
Crazy.
Did you refuse to plea? Is that why? Did you give some kind of resistance to pleading?
Absolutely. I object to the plea, and he overruled my objection.
Okay, well, no, what I mean is before he entered the plea on your behalf, since you were at the arraignment,
mm-hmm.
were you
mm-hmm.
giving any indication that you were not going to plea, or that you were refusing to plea?
Yes, I did. I did.
See, let me explain, so bear with me for a second here. I have a whole video where I go through the tactic of and I know you have this now, the tactic of using the unsigned plea of guilty. And that is because we know that they want to run over us, and they want to lie or try to misrepresent the record that you are refusing to plea. So we go in and to cut them off at the pass and have documentary proof that the judge is lying, and that's very valuable to have. We tell them that when the motion or the demur in this case is denied, or they just run over you and won't even hear it, then we tell them that we intend on pleading guilty, and we ask if the prosecution has met their prima facie burden. And just to head off all those people when they say that it's a conditional plea, it's not. If you read the document, and you've got it now. When you read the document, it's very, very short. It explicitly states that all appeal rights are waived. So it's not a conditional appeal. Conditional appeal is only one thing, where you are reserving your right to appeal certain aspects of the charge and the judgment. So don't let anyone lie to you. So just know when you go to court next time, or somebody else listening, you go to court, and the judge says, or the prosecutor, whoever, if they say, we don't accept conditional pleas, you say, fantastic, this is not a conditional plea. I am waiving my entire right to appeal. Okay? So we don't want to go in there and offer resistance. We want to be there in the spirit of good faith to resolve the matter. So if they have evidence that would, if taken as true, facts, if taken as true, meet the minimal standard of prima facie, would prove that their claim is true. I don't believe that they have that. I've talked with enough bureaucrats, right, and I talked to one today that I might relate later. Okay, so keep going.
Yeah, so at this point, I'm past the arraignment. I guess I'm going to the trial, and I was like, okay, is it too late to enter that plea?
The plea of guilty?
Yeah, if the prosecution can prove beyond a reasonable doubt that the code and the Constitution applies to me anyway.
Well, we're talking at this point prima facie. Until the trial starts, they just have to have prima facie proof. And so we're more than willing to, I say I'm more than happy to plead guilty and waive my right to appeal if they have that evidence. So you should be going to a pretrial conference, since this is a criminal, infraction, or a misdemeanor. You should be having a pretrial conference so that you can. Again, that's what you do at a pretrial conference. You are determining whether a trial is even necessary. And so you want to see what factual issues are in dispute, if any. And if there are no factual issues in dispute, then there's no reason for a trial. And so then you can, you guys can make a deal. So are you sure there's nothing in the docket that shows that you are having a pretrial conference?
I don't know, because it kind of got bad. I ended up getting kicked out of the court because I had, where I am in the state that I'm in, people are rude, and I had like golfers and people laughing at me, and oh, you think you're a lawyer, and like I kind of lost concentration and turned to the crowd, and and said some things and got kicked out. So
dude, we don't want to. We always have to come out, looking like the good guys, so that anybody watching is like, even if they're not, fully aware or understand what you're doing or even agree with what you're doing, they go, well, he was professional. I've had prosecutors that will say, I don't agree with your ultimate conclusion, Mark, but you are at least professional, and I get the logic. I understand what you're doing. I just don't agree with your ultimate conclusion. I mean, that was kind of thing that one of these lawyers said, because he said, even though my position was totally logical and reasonable and based on facts, because the ultimate conclusion went against his present, he said it was a reductio ad absurdum. He says, but your result is absurd. But if the result naturally follows the logic and is supported by facts, then whether you think it's absurd or not is not really a statement of whether it's accurate and whether it's true or a valid argument. It was just like the urban legend that bees were scientifically proven not to be able to fly, but the bees never understood. Well, it's not true. I mean, because maybe a better example of reductio ad absurdum. I would find out if you do have a pretrial conference, because what I would suggest at this point, and I'm getting lined up with calls, I would you've got the demur and you can file that because actually you're going to have to change the phrasing on the demur. You're going to have to change that to motion to dismiss, because you can only demur prior to a plea. Okay, so you can still motion to dismiss. It's the same basic thing, but we got a little terminology issue because of the statute, section 1004 of the penal code. So just change that, and then you're good to go. And I would file that with the discovery request and find out if they have on the docket a pretrial conference, because there should be. Either way, I would recommend getting into the Skype chat so that you can we can invite you into the Discord, where we normally would do that today, and they'll do it after the show, so that you can start doing some role playing and help get you prepped. So this way, if they're going to pull some stuff and they're going to be real jerks about it, it's easier because you've gone through it so many times with us guys that you can do a bit better.
Quick question, man.
Sure.
I have 1, 2, 3, 4, 5 different PDFs or files here. I see the demur, so and all of them say something different. You said, so file the demur instead of the motion to dismiss? No,
what you want to do is you want to open up the demur, and when because you have to edit it anyway for your situation. You got, that's what the instructions say. You got to have your name and address at the top left corner. You got to have the name of the right court that the complaint is filed into, the case number or docket number or ticket number, and there's a couple of other things that's pretty easy to follow. And you just need to go into the caption and change that from demur to motion to dismiss.
Okay, from demur to motion to dismiss. Okay. And do I keep the rest of the sentence there? Because it's more than just demur. It's demur to complaint and request for findings and facts. And do I erase all of that and just put motion to dismiss?
No, you just want to say it says your name hereby moves this court to dismiss instead of demur.
Okay. Oh, okay. Just put dismiss.
You're moving to dismiss. That's what a motion does. You're moving to dismiss the complaint based on, and then keep the rest of the language.
Okay. Yeah, that was my question. Do I keep everything else and erase demur, the word demur, and put, dismiss and motion to dismiss in place of demur? So yeah, okay. Great. I appreciate you. Thank you.
No problem.
I apologize.
We don't need to get into that on the air. It's cool.
Yes, sir. Yes, sir.
Okay,
yes, sir.
Appreciate the call.
I really do apologize.
Oh, not a problem.
Have a great.
Thanks. You too.
Have a great show.
Thank you. We have. He's been on the show before. Eric in Tucson. Welcome back to the show.
Yeah. Hey, Mark. Thanks. I was just listening there for a while, doing some paperwork in the background. How are you?
I'm doing fine. I got an issue with the troll here, but hey, we'll see how persistent he's gonna be. He says you can't leak anyone's number, dude. Not cool. But trolling my show and saying that's cool. So guys got kind of a twisted sense of what's cool and what's not cool. So anyway. So what's you have a good news to report?
Oh, no, my court date is on the 16th. So, I would like to find out a little bit more about, the difference between jurisdiction and standing. From your knowledge, the difference, if there is a difference.
Well, there is a difference, but standing, at least at the federal level and sometimes at the state level, but not here in Arizona. But standing is related to jurisdiction. The jurisdiction is the power. Okay. Jurisdiction is the power to act, as given by the Constitution. Standing has to do with the right of the plaintiff to seek relief if they have a justiciable or valid case or controversy that's right for the court to hear. And that consists of being able to have there's three elements to that, three general elements. And those are, there has to be a legal injury, there has to be damage, and the court has to have the jurisdiction and authority to redress the legal injury. And so if you don't have those three elements, this is why I think it's always jurisdictional. If you don't have those elements, then the court can't acquire subject matter jurisdiction under any circumstances that I am aware of. So if there is...
Can you state those three again, please?
Sure. You have a legal injury.
Okay.
Okay, and that in lay terms is the violation of a legal right or legal obligation. The second one is the loss, harm, or damage. It's the damage. So the Latin phrase is injuria et damnum. So that's the damage. That's the loss and harm that was caused by the violation of the legal right.
Okay.
And then redressability has to do with the court's jurisdiction and authority to be able to redress the injury.
Okay, got it. So, does that tie into the first, the two? There's no party that's been harmed. I thought that was corpus delicti. Is there some kind of overlap there?
Well,
the principle of corpus delicti.
The corpus delicti is a phrase that's used just in criminal situations, criminal prosecutions, to describe the same thing, the injury and the damage, or the act and the result that you would have in a civil proceeding.
Okay, so let's say, for example, a criminal speeding. I'm going 100, I get pulled over, it's class 3 misdemeanor. So that would be, so what would I be best to use in that situation where it is a criminal matter? It seems like jurisdiction trumps everything. Seems like.
Yeah. It's it's called the threshold issue, that nothing is relevant unless that issue has been resolved in favor of the plaintiff. So you don't talk about so-and-so killing, or causing, the death of B until we know for sure that the court has jurisdiction. Yes, I would agree with you that jurisdiction does trump it, because it doesn't, whatever A did to B is completely irrelevant if the court it doesn't have jurisdiction to hear it.
Got it.
But remember, Eric, is that jurisdiction is, whether it's subject matter or personal jurisdiction, is based on the same thing. And that is based on whether the claim is true that the laws apply because you're physically in Arizona, like the Constitution and whatnot. They're assuming this, and that is not even close to meeting a prima facie burden.
Got it. Okay. So legal injury was the first, loss or harm, proof of damage, number 2, and redressability, number 3.
Yes. And if you look at the court cases for Arizona, they're very specific, which is really nice. They talk about the corpus delicti being two things, the act and the result. And so when you look at a code violation, they're going, and they only have the first part typically. They have the act, but they don't have the result. And the result is really what they're punishing. That's what they're trying to redress. That's that's what they're trying to redress. So this is not the same thing as taking a gun and firing it, wildly, and just because you didn't hit anybody, you get to walk away. We're talking about there's no result, no one was injured, nobody was even potentially injured. There's no result at all because I don't have a driver's license or I don't pay a tax or whatnot. Right?
Right. Because I didn't plow into anybody at 100 miles an hour. I pulled over and that was it. And then I got my, of course, my citation. So, yeah, that's good. it's good for.
Were you really go?
Learning.
Wow.
So,
well, we shouldn't be driving that fast because you are putting people in danger.
Right, yeah, exactly. 100 is
Have
way
you
too
done?
fast.
Have you been doing role playing?
I'm sorry.
Have you been doing role playing to prepare for this?
That's what I need to do.
Okay. Oh, so you're the one. Okay, so I put you into the main chat, so let them know that you're on the show and you need the discourse link, and they'll get that to you. So I'm sure they're going to do it after the show, and help get you prepped.
Oh, yeah.
So,
but by Skype, right?
Yes, that's how we start.
Okay, cool. Yeah. Okay. Sounds like a plan.
All right. Any other questions? Just let me know. Skype me.
Thanks, Mark.
No problem. Appreciate the call, Eric in California. Wish him luck, and on confronting these bureaucrats, these criminals down there in Tucson, Arizona, to fall from the fortified compound. Let's see. Oh, I think this is California. We have area code 605. You are live on the No State Project. What's your name? Where are you calling from?
Can you hear me, Mark?
Got to bump up the audio, but yeah,
Mark.
Yeah, I can hear you.
Mark.
Yes.
Okay. Yeah. Hey, Mark. This is Dean from Minnesota.
Oh.
Are you there, Mark?
Yeah, I am. I was just surprised. I didn't recognize 6. I got the area code wrong.
Oh. One of the things that I've used, some of your stuff before, and when you go at it, to these I call them thieves. When you use this stuff towards them, they always want to retaliate. I mean, it's very quick, it's very noticeable, and then when you make a statement like that you're here to defend yourself, just like if you were an attorney defending, and they just want to railroad. I mean, they just like bulldoze over you.
Well, I get that, but what kind of retaliation are you talking about here?
Well, that's just like I went on the park, like I had a $7 parking ticket, and I thought it would be a good opportunity to use your system. And when I left the courtroom, and now I feel like it was retaliation. They followed, there was a PD that followed me, and I didn't probably get 100 yards down the road, and he pulled me over and wrote me another citation. So, maybe it was just by coincidence, but I look at it as retaliation.
Was the cop in the
especially
courtroom? Was the cop in the courtroom?
No, but I mean, when I went for the preliminary, and I was asking the judge who, if there was a conflict of interest, if the taxpayers paid him, and the taxpayers also paid the prosecutor, and asked these series of questions, you could tell that it makes them very uncomfortable. And then when I went back to, because they just set it up for court, of course, they set it out 3 or 4 weeks, and you go back and, and then there's a couple of deputy sheriffs in the courtroom and whatnot.
I've had it happen to me, blatantly happened to me. So I know, and I was able to bring out in court that this guy was stalking me. He actually went outside of his assigned beat, assigned area, and I had him admit on the stand because the judge was actually going to hold him in contempt if he didn't answer. Because we're talking about probable cause, and if he had followed procedure and contacted his superior that he was leaving his area, and he hadn't. Nothing came of it, of course. And that's, so is that the only time? Is that the only example of retaliation?
Well, I got a ticket down in Sioux City, Iowa. It was a violation, over with violation, and I went to court on that Friday. I went to the preliminary, And same thing, I was asking if there was an injured party, in basically how can the judge be representing, how can he in good faith, there not be a conflict of interest. But they always just railroad through that. I mean, they just, they push through them questions like they don't even hear you. It's like, and I've got to go back to court, February the 25th. And I'm going to, I need to put the motion to dismiss and all in. But one of the things that, I was wanting to talk to you about is, and you don't get in too much about this, is when they cover for the prosecutor. I mean, it's and if anybody that goes to court and asks these questions, it's blatant. The judge is just flat out covering for the prosecutor. And they just kind of, bulldoze through your motion and whatnot. One of the things that you don't talk too much about is the appeal process.
Well, I talk about the appeal on a regular basis. I don't spend entire shows on it, but I have done.
Right.
I have done like
because from my experience, they just bulldoze through. They just bulldoze through it, find you guilty. And there, I had one judge say, you know what, if you want to appeal, by all means, go ahead.
No, it's not.
But
even if they're reversed, it doesn't take a dime out of their pocket.
Right. Exactly. Yeah. And the appeal, but as far as the process, kind of the process to do the appeal and do it correctly, could you kind of touch bases on that a little bit?
So repeat that real quick.
I said on the appeal, because when they just bulldoze through these motions to dismiss and whatnot, the appeal process, can you kind of touch base on that and kind of walk people through that appeal, the appeal process and what it is it the filing, is the filing system or the filing, and everything kind of the same way?
Well, it's a little different, of course. You have to have briefs, and what you're doing is you're bringing to issues of error. So you're saying that the judge committed certain errors, and because of these errors rise to a level and are so bad that they affected you having a fair trial, and if you're not, if you violate, that's a violation of due process. Now, it may or may not rise to the level of a complete acquittal or having the complaint thrown out. It may result in having the complaint sent back to, the judgment reversed and sent back to the lower court to be retried. So that, depending on what error was actually committed. So if you have a denial of due process, which is why, let's say a denial of fair trial because the judge denied effective cross-examination, that is such a serious error that it usually warrants a complete and outright dismissal. Now, I'm sure, I'm not saying that that's absolute. They could send it back for a retrial with instructions that you have to, the obvious. But you're asking, for example, did the judge allow prosecutorial misconduct by allowing the state attorney or the county attorney to make legal arguments against me without having any actual proof? Or did the judge err by allowing a witness to testify without a showing that they had personal knowledge? That's why I focus on the cross, because it's usually something we can get every single time. So, for example, we asked them two questions. Did you determine on your own that just because you saw me physically in Iowa, that your laws applied and gave you jurisdiction and probable cause? And he'll say yes. So then you ask him the follow-up, what facts led you to believe that? And, they lose their minds. They object to their own witness. And so they say that it calls for legal conclusion when all you did was ask for facts. And so you can say, did the judge err by sustaining that objection and not allowing cross-examination? And then you have to show why you think that that is a violation. So what we do is say it goes directly to the witness's prior statements. It goes directly to his prior testimony and what happened at the stop. Because that shows that it's relevant. We also can show that the question did not call for a legal conclusion. The prosecutor acted in bad faith, and the judge erred by allowing it, because that gets back to what you said about covering for the prosecution. We know that he's covering for the prosecution because he's sustaining an objection that has nothing to do with the question. And so that's in a nutshell how we lay out these are the issues and these are the supporting facts to show that, yes, there was a denial of due process.
So in all of these cases, if you want to, let's say you want to keep a record, let's say you want to tape, not videotape, but just voice record, so you can keep track of all this stuff. Is there paperwork that you have to fill out before court to even do that?
Yes, because they want you to pay thousands for their transcript.
Yes, they do. Thousands. Yes, that's. Now, do you have paperwork on your website to enter that in?
That's a very easy one to draft up. You just have to draft up a simple one page. The rules allow me to record. I know it's up to the judge's discretion, which is why we're filing this. We want pre-approval to record so we can keep our own record. I do have to put in here, got to notice, even if you're able to do that, okay, there are places like New Hampshire where if you do not use someone from the approved vendors list to do the transcript, they won't accept it. It's not a matter of whether it's accurate or not. Did you go to one of our approved vendors? And you know that those approved vendors, because they're the only ones you can use in New Hampshire, they're gonna be as much more expensive, unless you can get it waived. So keep that in mind.
Absolutely. Now, one of the things, when you do your appeals, like when you appeal, as long as you ask the correct questions and on jurisdiction and standing, you have grounds for appeal. Once you take it to the next level, do you have that judge bias like you do I call it the kangaroo courts? Do you have that bias in the upper courts?
At the federal level, I'll say that in my experience, when it comes to the IRS, the bias is uniform. Absolutely uniform. They will always rule in favor of the IRS, except in very limited circumstances. At the state level, it's not as bad. There is bias. They have what I believe, it's an institutional bias because they are company men. They work for the state. And judges are overwhelmingly former state prosecutors. It's their former boss. So, the idea that they somehow shed that bias when they don the black robe, I don't buy it. I don't buy it. And that's why you can see sometimes such tortured logic in their decisions. Look at this at Brett I Like Beer Kavanaugh. My gosh, look at some of the defenses that he has for the Bush administration. Oh, because he was a Bush administration lawyer.
Mm-hmm. Right.
So I don't believe that the institutional bias that they have from being government employees and representing the state for 10, 15, 20 years before becoming a judge. No, psychology doesn't work that way, as far as I know. You just don't eliminate all that bias. So it is going to still be there. And that's why I think it's important to have such cut and dry, simple issues for the appeal, such as denial of cross-examination. Prove there was a denial of cross. I asked 2 questions, and the judge ended it right then and there. And I can show it was relevant. Relevance is very easy to show. We can show it's relevant. He just answered and said he determined on his own that the laws applied and gave jurisdiction. I want to know how he reached that determination. That's fully relevant for cross-examination. And again, anyone who tells you The contrary is lying to you. Any half-idiot knows that if he says that he had jurisdiction, follow-up questions regarding how he made that determination and why are subject to cross-examination and are proper subjects because they're relevant. It goes to his competency and credibility to have made those determinations on the street.
Now, so I don't know, and it's been a while, and I'm sure when it was all taking place, you were probably keeping up with it pretty close. But, one of the things about the O.J. Simpson trial was, his lawyers absolutely defended him to the letter. But, if you get a lawyer and you give them your motion to dismiss, they will absolutely just walk away from you. You can't pay them enough money to use it.
Granted.
Listen,
before you wait, I got to let you go here soon because I got to get at least one more call in before we're out of time.
Okay.
Lawyers have used what's called the Twinkie defense. There's I love how South Park parody, with the Chewbacca defense. Lawyers come out with some of the stupidest things imaginable that are completely illogical. O.J. Simpson's lawyers were horrible in that they were complaining about how Marsha Clark was dressed. That is not good. No, that is scumbaggery. That is douchebaggery of the highest order. That is, they were so petty and so, just a fire hose of crap that they did. No, they were horrible lawyers. Johnny Cochran was terrible, but he was good against, well, I can't get into all that. So, I can show the logical basis for my motion to dismiss based on a lack of evidence. And I can show where prosecutors, at best, their defense is, I don't have to prove this. Now, the fact that lawyers don't accept it, I don't care. What's important to me is it effective? And it has been and will continue to be effective and you can see the results on markstevens.net. The logic is there. The logic for the Twinkie defense? Ah, come on. And these are people with advanced university degrees. You're telling me Johnny Cochran deserves credibility as a lawyer because he said he was complaining about how Marsha Clark was dressed? That was only one of the stupid things that guy came out with. So,
well, I guess what I'm saying is they threw everything, the kitchen sink, the toilets, everything towards that case. And they never, one of the things that you notice is the courts never went after the defense as frivolous or you know what I mean? But if I get up there and if I start asking a few questions, then, it's funny how, you pay a man millions of dollars to talk about how someone was dressed. But I get up there and I ask legitimate questions, and it's like, you need to see the bailiff, or the bailiff will walk you out of the courtroom. And
you're touching on things.
It's funny. I guess that's what I was trying to, kind of parry there.
And I agree. I do have to get this last call though, so I do appreciate the call. And if you need help, get into the Skype chat. I'm Frank Rizzo 3. Get into the Skype chat and start doing some role playing so you can prep to deal with these criminals. Okay.
Is there a certain time to get in, or you just jump in anytime you want?
This is usually you can ask them if there's something going on, they'll let you know. But the set times where I can get involved is usually right now, but I'm doing the broadcast instead. So there should be something after the show. But get with me on Skype and I can answer more of the questions there. Okay?
Sounds good.
All right. Thanks. Appreciate the call. Dane in Minnesota, but I know he's been very patient. I don't have that much time. I can go a little bit over here, but 706, you're live on the show. Finally, what name are you going to go by? What name are you going to go? Wait, real quick, what name are you going by today?
Rush, R-U-S-H.
Oh, Rush. Okay. All right, Rush. So you had court.
Yep, had court. Monday, calendar call. Called my name, told him I was here under duress, coercion, and threat. The judge, he replied back stating, well, I'll take that you're here. And I objected, getting on the record that I am here involuntarily. And, under threat, coercion, and duress to set that precedent. So he made me wait to the end. Of course, got everybody out of there. Probably asked him one more time before I was able to get across from the prosecution, in regards to, what I want to do. And again, we took the script. Hey, have all intent of pleading guilty. In fact, I have unsigned plea of guilt right here. Just have a few clarifications, and so on and so forth. So I proceed to, once I finally do get my opportunity to, clear up, my clarification, I start off, hey, does it contradict yourself sometimes? How can I get a recording of this? Who can I hold accountable for getting me, recording audio or video of this hearing? He admitted that court, he proceeded and admitted that judges do sometimes make mistakes, and his intent is to try to be consistent, blase, whoop you want, bunch of bullshit. But he tried to, I guess from my perspective, put that on the record that judges do sometimes make mistakes. So I think that's something I can use against him, on my next court date. But furthermore, I have 2 court sessions, one in the morning, one in the afternoon. I went last in the morning, about 11:30. And, after I asked that question, I proceeded to, go down the script. I have a right to a fair means of hearing. He gave me a runaround. I repeated the question, objection, looking for a simple yes or no. So again, just trying to get as many yes and no's as I can on the record. So that we can later use that.
Okay.
Went down the line, in regards to, let's see, like I said, I'm hearing, do I have the right to defend myself without being threatened with jail? And, he went around the circles, yes or no. He went around the circles about something and kind of brought it back home that.
But let's get to the meat of this before we're out of time.
Okay, so meat potatoes, got him to contradict himself about 4 times in regards to a fair and meaningful hearing. I brought up the fact that, hey, I didn't get properly arraigned. I did on my first court date, did not have the opportunity to clarify my clarifications. However, the prosecution kept insisting that, hey, I don't want you to jail. He pretty much didn't want me to get in front of the judge the first time. So I signed no guilty. And up under that, I wrote uninformed. So I went with, hey, do I have the right to make an informed plea? And then we got down to the meat and potatoes regarding jurisdiction, and the elements of the crime. Is jurisdiction an element of the crime? So am I presume innocent of every, element of jurisdiction? Got him on the record saying, yes, you are. Well, he didn't say yes. He said, you are presumed innocent of every element of the charge.
Okay.
Jurisdiction element of the charge. Once I asked was jurisdiction element of the charge, choked him up a little bit. Hey, that's a good question. Mr. Russian, jurisdiction is.
Well, I'm glad. Yeah, that's.
Element of the charge.
It's always good when they say something like, he actually said that's a good question.
He said that's a good question.
Nice.
Mr. Russian, it's kind of complicated, but, justice is the element of the crime. Okay, am I presumed innocent of jurisdiction? Yes, you are presumed innocent of every element of the crime.
Nice.
As the prosecution presented any evidence of jurisdiction. And this is where it got funny. Well, we have an accusation here.
Okay.
Can we give them a copy of the accusation? They present evidence of jurisdiction, and can I get a copy? If so, can I get a copy, right? So, hey, we have a accusation here, objection, point of clarification. I'm not asking for accusations or any documents regarding accusation. We want to clarify if the prosecutor submitted any evidence of jurisdiction here today, yes or no. Every time I ended the question with yes or no or clarification with yes or no, he immediately stopped to gather his response. And was kind of getting frustrated, was letting me know that he knows that I know that I'm trying to get him to give me yes or no's. And not to run around all the bullshit. So, he kept playing me with his accusation paper, objection, point of clarification. His accusation is fact and evidence, right? Accusations are not fact, Mr. Russell. Okay, are there any facts and evidence, that the prosecutor submitted here today? Is this all you have? Is this it? Because this does not satisfy the element of jurisdiction. Has there been any evidence of jurisdiction? So I'm pushing this, right? Pushing this, giving me the runaround, keep pulling the accusation. He actually runs off the bench and said, hey, I'll get you a copy myself. Runs off the bench, goes to the back to print off the same shit they got. Accusation, count one, count two, state versus whatever.
Okay, I'm out of time. Rush, hold on. I'm out of time, so I have to kind of jump in here. You'll have to call, give him, I have a lot more time on the Saturday show, so we got 3 hours on Saturday, so call back then so we can finish this. I will jump in and say, I think this is why it's important to really not ask so many questions and really hit them at the foundation, because what they're actually saying when they say they have jurisdiction is that over you, especially over your personam, is that look, you're physically here in, let's say, Arizona, and because of that, the laws apply. So when they then say, we have the accusation, objection, non-responsive. What I'm asking you is what facts prove, or you could say, well, objection, are you saying that the accusation is actually proof that your Constitution applies to me? And that is a much better leading question, and if he ran off the stand before, he was that might get him to run out and clock out and go back home.
Right. And just, I know you got to go, but in short, I got to that on the second half. He reset and said we'll come back and do it on the second half of the day.
Oh.
And that's kind of when I got to, hey, is accusations fact? Does accusations, is this evidence that, hey, because I was state of Georgia that you have the quality? So yeah, I got that on the record as a leading question, definitely.
Nice.
And, I probably had 100 to 150 objections. He entertained them all. He was 2 years judge, pretty soft in my opinion. But
you need to do some prepping and because you are very lucky to have gotten dialogue on an objection. That is fantastic. So I got to give you an attaboy that you did. It sounds like you did pretty good. I'm very limited on time, so I haven't been able to listen. I'm not going to mention it on the air. But definitely do some more role playing and get prepped, and call me on the Saturday show, okay?
Okay, no doubt. Saturday it is. What time is that going down?
That is
what time?
4 to 7 Eastern Standard Time.
4 to 7 Eastern Standard Time. All right, I'll check back in when you get a minute. Take a listen to the clips. I got Kim and some of the guys in the other group trying to make it one wave, so I'll be role playing with them, and I'll check in with you Saturday.
Excellent, appreciate it. Thanks for the call. Yeah, it's great to be back, and it's great to have heard how Rush did. It's very unusual for those who are new listening to the big show. Very unusual for traffic court judges to give you dialogue and actually start discussing your objection. Usually they just don't give a damn. It's like Dane in Minnesota was saying, they just run over you. It's like you're not even saying anything. It's like you're not even there, because it doesn't matter whether you're there or not. It has nothing, because a lot, in their minds, it's already been decided that you're guilty. So, when you're dealing with, criminals, and why are they criminals? Because they're men and women who force perfect strangers to give them money. And it is no excuse to say, but they build roads, or they do this and they do that. Because it's not a defense if I steal from you, if I do something good with the money. At least it's not a defense when they accuse you. So, we don't get to say this is a nothing burger. It's nothing. It's a nothing burger. Witch hunt! We don't get to say that. That doesn't carry any water. It doesn't carry any water. Glad to be back. Looks like we've got the tech issue solved. The only thing we got is that, that minor, nonsense. I will be manning the board a little bit closer after this show, so hopefully that's not going to be an issue. But again, thanks to everybody. This has been episode 94 of the No Stay Project, here on my YouTube channel, and we'll be live on Saturday. Shouldn't be a problem. So, hey, till then, salud.